Patricia Van Haren, family law attorney. If I own something prior to marriage, do I get to keep it? Well, a lot of times that depends on what you owned and what happened to that during the marriage. So, for example, we had a client who had purchased a house prior to marriage. The house had a very low balance in regards to the loan, but during the marriage, the house had increased significantly in equity, and there were some refinances in which the wife's name was added to the title. Fortunately, we were able to negotiate out a settlement where our client was able to keep his portion of the home. We came up with a number that we presented to opposing counsel as to what we believe the community's interest might be in that home. And from that, we were able to negotiate a settlement where he paid a certain amount of money to purchase his wife out of the home. Had we gone to litigation route, the judge could have made a ruling that was on our side that would have agreed that our client owned a higher percentage in the house, or they may have been able to rule with the other parties who said that the community fully owned the house because of the titling issues and the fact that he had added the wife to the deed. Fortunately, we worked with our client to be able to trace back the evidence that he owned that property, including the source of the down payment and the funds that he had paid to the prior loan. And we were able to find that even though the wife's name had been added to title, there was another refinance during the marriage that showed that the wife was removed from title. With all this information and having the key evidence, we were able to send some letters to opposing counsel, present her with our evidence, and come up with a solution that was in the benefit of our client.